Hello and welcome, and thank you for joining us. We acknowledge the traditional owners and custodians of the many lands on which we work and pay our respects to Indigenous elders, past, present, and emerging. Sovereignty has never been ceded, it always was and always will be Aboriginal land. I'm Philippa McDonald, and this webinar is brought to you by compass.info and Elder Abuse Action Australia, EPOA, and funded by the Attorney General's Department. Financial enduring power of attorney. What's it all about? Recently, the Australian Human Rights Commission released a significant report, Empowering Futures, a survey of the understanding and use of financial enduring powers of attorney in Australia. It revealed 87% of people don't have a financial enduring power of attorney, that we know little about them. And this can open the door to serious financial elder abuse. Remember, if you need assistance or advice or feel upset about some of the issues we're raising today, please call 1-800 Elder Help, 1-800 353 374. We're joined by three wonderful panelists who come with first-hand experience of financial enduring powers of attorney. A principal, an attorney, and an eminent elder law specialist. We'll discuss what is an enduring power of attorney, how are they set up, and how each participant navigates their roles. Bill Yates advocated for his dad, who had dementia. 5 years ago, he received a diagnosis of younger onset Alzheimer's disease. He's a champion swimmer, a husband, father, and grandfather. He's passionate about advocating for the rights of people with dementia and Alzheimer's disease. He's going to tell us what he's got in place and why. Julie Tremaine is an attorney for her mum and previously her dad. She works for the Senior Rights Service and is the Older Persons Advocacy Network's National Contact Centre Manager. She will be sharing her tips, especially around communication, the importance of shared decision-making and accountability. Brian Hurd is an author, presenter, and partner of Brisbane law firm HopgoodGanim Lawyers. He has extensive experience in life planning for older people. Brian is the author of Avoiding the Aging Parenting Trap, and he was awarded the 2021 Australasian Journal on Aging Book Award. He is also a member of Elder Abuse Action Australia's Senior Panel for Advocacy Rights and Knowledge, known as SPARK. Now, we want your questions in our Q&A box, and we are running a poll. The poll is, do you have an enduring power of attorney in place? First up, let's hear from Brian Hurd. Brian, in simple terms, what is a financial enduring power of attorney?
Oh, hello, Philippa. It's a document, to put it simply, a document where you appoint someone effectively to make financial decisions for you, should you ever lose the capacity to do so yourself.
And then what do we mean by principal?
The principal is the name given to the person who actually makes the document. In other words, they appoint people as their enduring power of attorney. So they're the main person in the document making the appointment.
And what do we mean by attorney?
Well, the trouble with that term, of course, is that it is very Americanized and it's been infected by American terminology where American lawyers are referred to as attorneys. So a lot of people have the misconception that an enduring power of attorney is where you appoint your lawyer, but it's not the case. An attorney is simply a person over the age of 18 who can agree to be your attorney under the document where you're appointed.
And what's the difference between an enduring power of attorney and a power of attorney?
A power of attorney has a similar effect. In other words, you appoint someone to make decisions for you financially if, for example, you go overseas. The difficulty with the power of attorney is that the law says it comes to an end if you should lose your capacity. So the law introduced some years ago a new type of power of attorney called by the word enduring power of attorney, which means the power of attorney endures. It keeps going after you lose your capacity. So it's just a branch of a power of attorney with the word enduring in front of it.
So we're getting some crucial details here from Brian, and compass.info has a full glossary of these terms. Just go to compass.info. That's compass.info for a glossary of these terms. Brian, what's more important in your life planning, a will or an enduring power of attorney?
Well, I might be taken out and shot for my answer, but from my experience of dealing with older people and their families, to me, the enduring power of attorney is, if you're going to give it a priority, more important than a will. And the reason for that is that if you don't do a will, then the law prescribes what happens to your estate when you die. In other words, there is an answer, there is a solution. However, if you don't do an enduring power of attorney, the law doesn't prescribe what happens then. The law requires someone to take some legal action to fix the problem where you haven't done an enduring power of attorney. And the trouble is, these days, because of longevity, many more people are falling into that later stage of life where capacity becomes a major concern. So an enduring power of attorney becomes a major issue that needs to be addressed before you reach that stage. Hopefully you never do, but many people are because of living longer.
Well, then that raises the question, what are the consequences of doing nothing? Can you give us a couple of examples?
Australians are really good at doing nothing. It's cheap, it's free, and it doesn't require a lot of effort. And the problem is that if you don't do an enduring power of attorney and you lose your capacity, nobody in the entire world can make financial decisions for you. Not your spouse, not your children, not your next of kin. So you are in what's called a legal black hole. And that means that someone, as I mentioned before, has to apply to a tribunal to be appointed what's called your administrator. Now, what that means, of course, is a legal process. It means delay. It means cost. Whereas the solution to avoid that would have been simply to do an enduring power of attorney.
Well,
Now,
give us an example of what you might see.
I see an example recently, for example, where an 83-year-old woman who was the sole director and shareholder of a very large family company and was the total controller of the company. She was the only person who could sign checks. She had 4 adult children. 3 of them were lawyers. One was they say, adopted. She was a social worker. She's sitting, the mother, 83 years old, at her desk one day signing checks, and she has a massive stroke. She's in hospital, loses her capacity, is in a vegetative state, has never done an enduring power of attorney. Consequence, her financial affairs are frozen. Even worse, her family company's financial affairs are frozen because she's the sole director, shareholder, and check signer. Consequence of that is someone has to apply to a tribunal to be appointed her administrator in order to unfreeze her financial affairs and that of the company. Next problem, none of the children could agree who should do that. So they all competed with each other and applied individually. They weren't appointed because there was too much conflict. And as a result, the benevolent bureaucrat, the public trustee, was appointed in their place. Now, all that took 6 months. The reality is, of course, it cost a lot of money, $403,000 in legal fees, not to mention if that lady had come to me to do an enduring power of attorney, I would have charged her substantially less than that sum of money. But the reality is that's what it cost her affairs to avoid having to do something properly, which she could have done initially, and having to force her children to go and, as a result, to a tribunal to get appointed and then fail. Can you imagine the legacy of family implosion that caused? So mums...
What kind of legacy? What happened to the business?
The business was ultimately, because the public trustee is not in the business of running small companies, so it was liquidated. The public trustee liquidated the company, sold it up, and as a consequence, this very large, long-term, very historic, iconic organisation, family company, came to a sudden crashing end. None of the children talk to each other anymore. The legacy of relationships has imploded their relationship, and as a result also, it infects the people down the family chain. So none of the children talk to each other. So the cousins also are incommunicado because that's what their parents want. Now, that's a really classic example of doing nothing.
Wow. Now, we've got some links in the webinar chat to the glossary on Compass. So take a look. And there's also a link to Enduring Powers of Attorney section on Compass, and they're really useful resources. Well, then, Brian, how carefully should you choose your attorney? Is it always the obvious person in your life? What are some of the key considerations?
Hmm. The key consideration initially is to take the task of choosing seriously. In other words, consider who the candidates might be. For example, traditionally, husbands and wives appoint each other, and that's usually common and reasonable. But then it's very important to appoint alternative people in that document if your partner or spouse can't perform the role. So that then becomes the issue. Should you appoint the children? If you've got 7 children, it's not practical, obviously, to appoint all 7 as your alternative enduring powers of attorney. So what you've got to think about, it's a diplomatic, delicate exercise to determine of the children, who should you appoint? And the reality is you should not appoint 7. That leaves you with a delicate task of appointing who. So we have, for example, the strong advice to people when they've got this sort of conundrum, what they should do is think about how they do the document intelligently. So, for example, they could appoint 2 of their children and require those 2 children to tell the other 5 children of the decisions they make. So they include the other 5 who don't have the decision-making power, but the 2 that do make it a practical document because only 2 need to make the decision. So in terms of choosing appropriate people, family members are usually appropriate, unless they have some issues, of course, which makes them inappropriate.
What
Or you
issues are you talking about there, Brian?
Well, for example, where children, a particular adult child, ends up being the carer of their aging parent, and they live with their aging parent, it can be entirely inappropriate to appoint that child carer as mum or dad's enduring power of attorney, because clearly they have an interest in mum's affairs financially even, and at the same time have to make decisions in the best interest of mum. That can create a conflict of interest. And the other thing is, don't choose your attorneys on the basis of their expertise. For example, I had a client who had a son who was an accountant and a daughter who was a nurse. So they decided they want to appoint the son accountant for financial decisions in their enduring power of attorney and the daughter nurse for personal and healthcare decisions based on their expertise. Big mistake. The issue was the demarcation problem. When was a particular decision a financial decision or a healthcare decision? And a lot of times those 2 domains in our life overlap. So you end up then have this legacy problem between the 2 of them of who is the appropriate decision maker in the circumstances. So you should definitely choose people who are younger than you as opposed to older than you and who you believe have common sense and the capacity to do it in your best interest, bearing in mind they can't be paid to do it. And it can be a very time-consuming job. I've been enduring powers of attorney for people, and I can tell you it's a very time-consuming job.
To meet your responsibilities, to have that level of accountability, and to have some shared decision making at the centre of your dealings with that person.
That's right, exactly. You've got to have some empathy with their circumstances, some idea of their wishes, desires, for example, because the person themselves, the principal, can't tell you because they've lost their capacity. So having this empathy for their concerns and circumstances can be very important when it comes to making decisions in the best interest, which is the overriding theme of being an enduring attorney. Decisions in the best interest of the person for whom you are the attorney.
And look, thank you for that, because you've already answered one of the questions that was in the Q&A box, and that is, can you have more than one attorney? And yes, you can. And the other question that's come up is about fluctuating capacity. Have you got any thoughts there?
Yes, I do. Capacity is a chameleon. It does fluctuate. It's episodic. And you can think someone's incapable when the law would say they're not. So, for example, the definition of capacity in Queensland is 3 criteria have to be satisfied. 1, you understand the nature and effect of a decision. that you can make that decision freely and voluntarily, and thirdly, that you can communicate that decision. So if you can satisfy those three criteria, then the reality is the law would say you are capable of making that decision. Now, if you have fluctuating capacity, which is quite common because most incapacity is not pervasive. So the reality is it can come and go. And for example, it can be a person who is capable in the morning but incapable in the afternoon. So the issue with fluctuating is to get a person, when they come to do the document, at their best moment, as opposed to their worst moment. And generally speaking, with experience with that person, you can judge that. But if there is a doubt about a person's ability to make a document, what lawyers normally do is to get a medical practitioner to advise or give an opinion about whether that person has current capacity to make that document or to make that decision. So if that doctor says that's their view, that's very helpful in satisfying the test of capacity to do something. But the lawyer, in the end, if the lawyer is involved, needs to make their own assessment based upon that medical opinion.
Thank you. And if you're making your financial enduring power of attorney, how specific should you be? What details should you include about your wishes?
Yes.
I mean, a lot of people, it might be their cat that's the most important person in their near family.
Yes. And in fact, I've had a client where that was the case. In other words, she had no family whatsoever, no close friends. Her only friend was her cat. And when it came to making an enduring power of attorney, her major concern was to appoint someone, not the cat, to appoint someone who would look after the interests of that cat. Because the only purpose of her making an enduring power of attorney was to make sure that cat was looked after if, in fact, she lost her capacity. So if you can imagine the scenario, she's lost her capacity and there's the cat purring away. Who's going to make decisions for that cat when she can't? And what sort of decisions would that person like the attorney to make? So you put those types of wishes in the document so that the person who's making decisions for the cat knows what you would want in their best interests to do. So those things, people treat the enduring power of attorney document as a beige bureaucratic form, but it's something that needs to be crafted to the interests of the wishes of a person, particularly where they have an idiosyncratic lifestyle, for example, making it sure that the attorney knows what you wish and want should you lose your capacity in terms of the decisions they have to make.
Well, here's the big sleeper. How can financial enduring powers of attorney be misused, intentionally or otherwise? Where's the tipping point for elder abuse?
There are two forms of abuse of enduring powers of attorney. One is called innocent abuse or misuse, and the other is intentional misuse. A lot of people who are attorneys never understand that, for example, if they're the children of a mum, that they're not children anymore. They are enduring powers of attorney. They're wearing different hats. So when children become attorneys, they are now attorneys, enduring attorneys, not the adult children. Therefore, they have all these responsibilities. They don't know that because they don't understand their role, because they don't read the document to understand what their role is. So they proceed as if they were a child of the parent and not an enduring power of attorney, which means they mix their money. They take money from mum and use for what mum would have given their approval for anyway. So they assume that they're doing the right thing because that's what mum would want, without realizing the hat they're wearing, which is the enduring power of attorney. I've got lots of cases where that innocent abuse has occurred. Where it becomes intentional is a dramatic concatenation between the power of an enduring power of attorney and online banking. Because the enduring power of attorney is essentially a private document between people. It doesn't have to be registered on a public register, except in certain circumstances. Then you've got an online bank account, which you can operate from your bedroom. So the two private operations come together for attorneys to use the power on the online bank account without any scrutiny or accountability until they're discovered. And they're usually only discovered when the mum or the dad has died. So they use it like a honeypot, thinking they have the power and they have the access, and there's no scrutiny. Banks are becoming more alert to this, but slowly, because they hate to invade people's privacy. So the online access and the enduring power of attorney come together, as I said, to create this opportunity, this greenfield site for people to misuse the document because it's so easy. It's there to be used and no one's watching.
Well, then how hard or easy is it to revoke a financial enduring power of attorney?
Well, if you have the capacity to do so, you can do so. In other words, you can sign a document, in Queensland at least, where you revoke the enduring power of attorney. But you've got to have the capacity to understand what you're doing. And that capacity requires the capacity to understand what a revocation means. It's a big fancy word, bringing to an end the enduring power of attorney that you previously made, and understanding as well that by doing that, unless you do another enduring power of attorney to replace the one you revoked, you don't have an enduring power of attorney anymore. So two things are required to be understood: what revocation means and what not doing a new one enduring power of attorney means. So it's a challenging exercise to revoke it because you need to replace it.
Pretty quick, smart. And
Very
we've got a question. Can we please hear the three criteria for determining capacity again?
One, you need to understand the nature and effect of a decision. Two, you need to be able to make the decision or the document freely and voluntarily. And thirdly, you can communicate your decision as the third and final criteria. All three criteria must be satisfied in order to be found capable. All three, not one or two, three.
Thank you. And we've got Christina saying she's her brother's enduring power of attorney, and due to cognitive impairment, mental illness, drug addiction, and homelessness, she's attempting to make him safe and well as possible. If something happens to her, what should she do? Because she's in this role.
Two things. One, there are two enduring powers of attorney required in this situation, if possible. One is for her son to have one, if that's possible. In other words, if he has a moment or a time of capacity for him to be grabbed and do one to appoint, for example, her. The second thing that needs to happen is she needs to do one. Because if she's not capable of making decisions, for example, for him, someone else has to make decisions for her. And that's where she has to put in those special wishes and conditions about what decisions she wants that attorney she appoints to make for the benefit of her son in particular. Not just her, but her son as well.
And I think it was her brother that she was talking about, but
Right.
that still applies, yes. And
Thank you.
thank you. And look, we want to move on to our other wonderful participants, but we've also got an anonymous attendee saying, at what point would you deem that someone is not acting in the best interest of the client?
If they're enriching themselves with the money from the client or the principal, for example, or if they're not doing something. In other words, they simply fail to do something. And the biggest failure most attorneys have, financial attorneys, is not getting advice on what to do. In other words, they simply keep it to themselves and they don't get professional advice, for example, from a financial advisor or an accountant about how to act in the best interests of the person for whom they are the enduring attorney. That's the best protection an attorney can have against allegations they've done or haven't done the right thing, is to get advice about what they should do. But of course, that means spending money. And they think they have to spend their own money. But where that advice is got for the benefit of the person for whom they're the attorney, they can use the money of the attorney, of the principal, to pay for that advice, because that's acting in the best interests of the principal. So getting advice is the biggest solution to any allegations that you've done the right or the wrong thing.
Thank you. Now, don't forget the Elder Helpline, 1800 Elder Help, 1800 353 374. Now, remember the incredible resources on the compass.info website. Now, perfect time to bring in Julie Tremaine. Julie, you're coming from the perspective of an attorney. Describe, please, your direct experience and why it was necessary for you to become an attorney.
Hi, Philippa. I guess firstly, I didn't always have knowledge around future planning documentation like enduring power of attorney. It's probably I've been in aged care for about 25 years, but it's not something that you generally just come across. So it wasn't until I went into my role as an aged care advocate with Seniors Rights Service and through doing advocacy work and interacting with our legal team that I actually learned and understood the importance of having that sort of paperwork in place. So I have my parents, I have my dad who turned 90 last August, and my mum's 86. And my dad's health was starting to fail at 90, as it does. And they had that old, I guess, fashioned relationship, I'll call it, where they were married for 67 years. Mum got her housekeeping money every fortnight that she could buy the groceries out of, and the bits that left over were hers for savings. And Dad basically managed the bank accounts and all the financial side of things, paid the bills. So Mum doesn't have a lot of knowledge around managing finances. She also doesn't have a lot of education. So I started discussions with them just before Christmas last year about the importance of getting future planning documentation in place so that A, they could stay in control and have choices around how they wanted things to be done, because that was a huge thing for me. And also, one of Dad's biggest concerns was always having enough money in the bank so that if he died first, which he always thought he would, that Mum would have enough money to see her out until it was her time. But he was also concerned about how she would manage it after he'd been managing it for 67 years. So that's when we started those conversations about getting future planning documentation in place, and the enduring power of attorney and a power of attorney as well. So that's where we started the journey.
Where did you turn to?
So although I had some knowledge, I have by no means legal knowledge. So I needed to find someone that we could talk to with legal knowledge that could help us do all that paperwork. Mum and Dad are pensioners, they're not flush with cash. So I was looking for the free option first. So I sourced a local community legal centre that could help draw up that paperwork for us. So it was really easy. It was 2 visits. I took them along for the first visit, went into the room with them, but then I left the room because it was really important that they were getting independent information. I'd told them about it and I'd given them resource material, but they were getting independent information from a legal perspective. And by me not being in the room as well, I wasn't influencing any of the conversations or any of the decisions that they were making. So they were able to do that one-on-one with the solicitor. We left, he drew up the paperwork, we came back, he once again went through all the paperwork with them, and once they were content that they understood what they were signing, it was really important that they understood. Paperwork was signed and it was done. It was a really simple process once we knew what we had to do.
Well, then how did you navigate family dynamics?
Yeah, so that can be tricky. Like most families, we don't always all get along. So I have 2 brothers, and we were estranged from one of our brothers at that point in time. But when Dad's health started to fail, one of his wishes was that his family would be whole again. So we had to be adults and, suck it up. And we had a discussion amongst ourselves and decided, the Mum and Dad's welfare, we needed to bury the hatchet and just get on with it. So my brothers have always been the practical ones that go in and will mow the lawn or fix something that's broken. And I'm the only daughter, so I've always been the one that's jumped in and helped them with appointments and financial matters when they needed me to do something. So I guess I've been doing it for a number of years, but it was informal. There was nothing formal in place. My parents spoke to us all one-on-one, and everyone agreed that I was the best person to be their enduring power of attorney or their attorney. And should something happen to me, then my 2 brothers would step in and pick it up. It wasn't a hard decision because they didn't want the responsibility. I guess it's not only about a person being capable of doing the job, but it's also about the person being willing to do it. And it is time consuming. You're dealing with banks and telecommunication companies. It can be complex at times. So it was just something that they didn't want to take on board. And it wasn't practical to have all 3 of us appointed at the same time, because the longest part of getting that paperwork put in place was us finding time to go in and sign it all one by one. It took us nearly 2 months for us all to get an appointment that worked in with our schedules to actually sign that paperwork off. So yeah, it all quite worked well, but the big thing was communication. We had to talk as a family. And that way, whatever I decided to do, my brothers knew that it wasn't my decision, it was that my parents had made the decision.
Exactly. Look, we're getting so many questions on the Q&A, but let's just address a couple quickly. Someone is saying that they've got a power of attorney. It's written, but it's not signed. Where does that leave that person, Brian?
Useless.
Okay,
It's
so they've got to
a
get on to
useless
that.
document. Useless document. It's just a piece of paper.
And another check-in, we've got a couple 84 and 79. They've got an enduring power of attorney they made 40 years ago. Is it still current?
Yes, if it was made validly at the time.
So it might need a bit of check-in there.
Yes.
So back to you, Julie. Thanks, Brian. As an attorney, what are your responsibilities? And what about accountability and the best way to keep things separate?
So it's a lot of those things that Brian mentioned. So my parents didn't put any restrictions or stipulations in the actual paperwork, so there were nil conditions in it. So I guess the first thing is that I need to honour my parents' wishes and act in their best interests. I had a lot of those hard conversations with my dad before he passed, like a couple of weeks before he passed away, while he still was able. We went through the safe and we went through all the paperwork. We went through all of his investments. So I knew exactly where things were and what needed to be done. So it can be confronting having conversations like that when you know someone's at end of life. But it was really important so that I was organised for when I had to then step in and take over with things. Brian mentioned keeping funds separate. My funds and my mum's funds do not cross over in any capacity. I keep records of everything, so I don't have the enduring part activated yet. I'm just mum's power of attorney, but I effectively do everything I would be doing in an enduring capacity as well. But I still keep her included. If I make a purchase or I pay a bill or I withdraw money from the bank, she always gets the receipts. I always tell her what the balances are. I always show her the online banking. And I make sure that she still gets the paper copy of the statements that come out every 6 months as well. That's not only so she can go through it and question me if there's anything there she doesn't understand or she's not sure of what the purchase was, but it was something that her and my dad used to do together. They used to go through the statement together. So it's still giving her a little bit of her old world and some control of what she used to do. Shared decision making, I will never go and just pay something without consulting her first and letting her knowing that I'm doing it. And it is an unpaid role. I don't give myself an extra $50 out of the account when I withdraw money for doing the job. You do it for the love of it. And at the end of the day, I have to be able to live with myself. So I'm always honest about everything I do with her because I've got to live with my own conscience.
What advice would you give others listening in today who might find themselves sort of on the edge of a role like yours?
Um, Look, it can be difficult. Mothers and daughters, we don't always get along. And, I have had recent words with my mum and I have to separate it. Once again, Brian said it's a job you've taken on. And so I have to put my personal feelings aside and leave that part to the side. But when it comes to managing her finances and doing that role, I just have to do the job. Sometimes it means that I have rung my brothers and said, you have to be the conduit for information until we sort our grievances out, which are usually over within a couple of days. But it is about recognizing that the personal relationship does have to sit to the side of it, that you can't just stop doing it because you're upset with someone or something's happened that you don't want to interact with them.
Now, I hope I'm not overstepping here, but this is a question in our Q&A about what about travel expenses? I mean, you live in regional Australia.
Yeah, I don't have a lot of expenses that I wear really with managing mum's money. But mum's very fair and reasonable. She is, I guess, often wanting to give us money, and she gives the grandkids money all the time. And I'm always having to remind her, Mum, it's lovely that you want to give them gifts, but you need to have enough money so that you can afford to live comfortably till your time comes. So Mum would always come forward and actually offer if there was cost to me. But I would never just take it. It is not my money to take.
Can I have your thoughts? Because you have a number of hats in aged care and seniors' rights, as well as being an attorney. What about putting in protections to mitigate elder abuse when it comes to a financial enduring power of attorney?
Yeah, I think a lot of it's around who you choose. Like a lot of people do go the default of just family. Sometimes family isn't the right person. It needs to be someone who knows your wishes, who'll honor your wishes, someone who you can trust. And I think you need more than one pair of eyes over it, so you're held accountable. So with my family, although my brothers aren't power of attorneys, I still feel like I'm accountable to them because look, at the end of the day, what's left over is in the will and it will be divided up amongst us three children. So in a way, I feel that I'm still accountable to them in what I'm doing. So I think transparency and actually making sure that there are other eyes watching on what's going on is a big thing to protecting people. And doing that forward planning. So I talked about future planning documentation. We did the whole suite, enduring guardianship, financial, and even advanced care directives. We did the lot so that my parents had total choice and control up until the end. And that also provides a certain amount of protection against elder abuse if you're appointing the right people.
Exactly. And look, what has come up in the Q&A is that some people are saying that they haven't got that family member, they haven't got that friend, they haven't got someone they can appoint as an attorney. What are the options, Brian Hurd, if you've got no one in your world and you need to go outside? Can you go? Where do you go? Where do you turn?
You've got a number of options. One, you can appoint a professional person like, or ask them at least, like an accountant or a financial advisor. But my experience, or a lawyer, my experience is most of them are reluctant to take on that role for perhaps obvious reasons. The other alternative is to approach, for example, the public trustee. So the public trustee can agree to be a person's financial enduring power of attorney as a last resort. So to that extent, there are always options for you where there are no obvious candidates within your circle or family that will fulfill or would be agreeable to fulfilling that role. And what you need to bear in mind as well is that if in fact you agree to accept an appointment as an attorney, you can resign at any time, provided the person still has their capacity when you resign. If you want to get out of it, after the person has lost capacity because it's all too hard, then you've got to go off to a tribunal to get their approval to resign. So it's not something you take on lightly. And that's why professional people don't like it, because also they have to charge to be the enduring power of attorney. So that's a disadvantage, for example, in appointing professionals or indeed a trustee, such as the public trustee. But they are options.
We've got someone saying that their father appointed the New South Wales trustee and guardian, but it still didn't stop the account being drained by another family member. Got to be careful here, but
Well, the reality is, of course, that there are authorities put in place by people during their life when they've got capacity, such as signing authorities on bank accounts. Now, that's a separate authority that may not be an authority given to the enduring power of attorney, for example. And no one questions it. In other words, that assigning authority or operational authority just carries on, even where there's an enduring power of attorney in place, because no one questions it. So I've seen people use that banking or withdrawal authority while there is a different person as an enduring power of attorney, because never the twain shall meet. The left hand didn't talk to the right hand. So look, it's very complicated, particularly because there are so many alternative substitute decision makers out there. You know, we've got nominees under Centrelink, people called payment nominees, correspondence nominees. They're not necessarily enduring powers of attorney. They're just created by the legislation. And there's lots of legislation that does that. Even under the Aged Care Act, we've got representatives. They may not be enduring powers of attorney. So it's very messy. That's why a
wow.
person's circumstances have to be properly reviewed.
Well, thank you, Brian. Now, Bill Yates, welcome back to Compass. Thanks so much for joining us. Your video got so many watches and is still going viral. When did you know you might have younger onset Alzheimer's disease, and how has this changed your life?
Hello, Philippa, and hello, everyone. For me, as a school teacher, it was actually in the classroom, um, where I sort of underst knew everyone's names, the teachers, the students. It suddenly became a problem. I was a teacher of physics and chemistry. I couldn't remember the theory, yet I'd sort of been gifted with a photographic memory. And when it came to using equations, I just suddenly couldn't remember them. So from my perspective, it just became fairly evident that there are issues happening. Um, for me, when I finally got my diagnosis 5 years later, um, it was horrific. In one sense, I have to say to you, it was a relief because I finally knew an answer to what was causing all the problems. But then the anger and feeling upset and all that started to set in, and being a incurable progressive disease, it really hits home. Everyone has dreams, they have aspirations, they have hopes for the future. And I found that was suddenly gone. And with the diagnosis of younger onset Alzheimer's, for me, it was more than a cognitive decline. It was like a rule. I'd lost my own self-identity. So the impact on my family and me was for me devastating.
Thank you for sharing that. When we met earlier this year and spoke about enduring powers of attorney, you didn't have one. What's changed since then?
For me, Philippa, it was very much a wake-up call. Um, there's me for years been talking about the importance, the need to plan for the future, and I hadn't done it. So I've now addressed that issue after a lot of thought and a lot of discussion. I have one in place.
Can you tell us a little bit about it? Who you've appointed as your attorneys and how it all works with your kids as well?
Initially, I thought it was going to be quite a difficult task. Without going into my personal circumstances, I did look after my father for 4 years. There was a big split in our family because planning for the future wasn't done correctly. Um, so I needed it from my own experience to get it right, to avert all the issues that I came across. Um, in the end, I settled I have an identical twin brother who has no symptoms at all of Alzheimer's disease. So he was a logical choice, and I chose my wife. I do have 3 kids, and in some way, when I factored everything up as to what I really needed, um, my choice still came back to my twin brother and Nicole, and they are my 2 attorneys. But I have my kids involved too, of course.
In the event you lose capacity, how do you want your money spent?
See, the interesting question. I'd answer it by simply one phrase first. Life has to go on. And what I meant by that was that the diagnosis brings a reality. There's a finality attached to it. At the end of the day, I need the money that I have to obviously care for myself, in the sense that I need to be placed in a home 24/7, cared for. My wife, Nicole, needs to be cared for. But at the end of the day, my estate, we'll call it 50/50, given all those things are set up, then from my perspective, that money needs to go to my kids. So in terms of what I've set in place is very much dealing with those 3 things. So when I talk about how will I split the money, it will eventually go to my kids, provided everything is set up for my wife.
Well, as someone with a diagnosis of younger onset Alzheimer's disease, you've spoken to me about the strength of character you require from your attorneys. What do you mean?
I found looking after my father, and the bond, we've spoken about it before. There's an amazing bond between yourself and your parents, and I think it deepens as you care for your parents, especially as they're going through dementia. And from my own experience with other people, is that you dearly want to look after your parents as best as you possibly can, and you go the extra yards. But there's a huge burden attached to that. It's not just you who's suffering emotionally, but your family, relationships get strained, and all of that will happen. So for me, a strength of character is that you understand, I understood my father's wish. His family was important to him. So therefore, the strength of character I had needed to do was to be able to make that decision that it is time to move you out of home and go into 24/7. And I understand that is a very, very difficult decision. It's like putting your hand up and saying, look, I'm failing to look after my father in my case. So it's a strength of character to realize when you need to make that decision that I refer to. And might I add, when we last spoke, I spoke of strength of character in relation to the attorney. Since doing my enduring power of attorney, I've also realized that strength of character also refers to me. I have to have the strength of character to put things in place the way that I want to, realizing there's finality attached to my life.
And to you, how important is communication and the role of supported decision making?
In what I've sort of set up in my own enduring power of attorney, I actually regard communication as the key factor. And in my experience with my father, I think that was one of the things that led to our downfall. And Julie's spoken before about the whole thing of you might make the decision, it's decisions, but you need to communicate that to everyone in the family. And just like where I've got Peter and where I've got Nicole, it's really important that initially I'll do that communication because I'll still have capacity, but I understand that where I've decided I'll do that on a yearly basis to communicate to everyone, this is where I'm sitting, this is where everything's happening for me. I know that will change and might go to 6 months, it might go to 3 months. But for me, I need to be transparent. I need to explain to everyone around me what is going on and where the money is going. So that's, to me, the whole idea of communication is exceptionally important. When it comes to support decision-making, I understand that as the disease progresses, and Brian spoke of fluctuating capacity, and I've experienced that. And to me, shared decision-making is so important that, for example, my twin brother, Nicole, they understand my wishes. They understand what I want in place. But as my behavior changes and as things change in me, I expect them to remind me of, what is the most important thing to me. So we're making a decision based on what I really want. So shared decision-making is crucial to everything, especially as this disease progresses.
Thank you, Bill. I really appreciate this, and your perspectives is so crucial to this conversation. And I'm just wondering whether anyone would like to come in here and has something to say about what Bill's just said.
I think both Bill and Julie have made a good point about the issue of communication. And that communication starts when people, particularly Julie's circumstances, where the adult children are proactive in raising this planning issue with their parents, for example. because the parents are always reluctant to raise it with their children. So to that extent, adult children, I think, are specially placed to ensure that their parents are given information and they raise with their parents these questions and issues. Because if the adult children don't, the prospect for the adult children in the future is quite bleak when it comes to the consequences of their parents doing nothing. So it's in the interests of the adult children to raise it, as much for their own interests, but also ultimately for the benefit of the parents. So it's this communication coming from the adult children to spur the parents to do something that's so crucial to getting something done.
And Bill's in a unique situation of actually having been very proactive about it himself.
Exactly.
And to sort of, I suppose you're protecting your children for a bit by having
Yeah.
your wife and your twin brother, but they are still dealt into the whole equation, Bill.
Yes.
Yeah,
Parents,
and I think
parents
it's
will
so.
be, sorry, go ahead, Bill.
I think it's so important from my perspective is that I don't want my kids to feel that they're left out. So communication to them is so important. And I actually want them to have a say too. So at the end of the, and Brian spoke about getting advice and Julia. And from my perspective, it's so important to get advice from my three kids so that they understand they actually have a role to play in this. And without going into the details of it, I've put in perspectives for them that should this occur, that I want you to now step up and become involved in the management in my journey. So yeah, and hopefully that way is that relationships don't get affected, that in fact they work together as one. And that's probably my biggest goal.
Thank you. Now, we did have a poll at the beginning of this webinar. We asked you, do you have an enduring power of attorney in place? So drum roll. What is the answer here? Do you have an enduring power of attorney in place? Yes or no? And the hosts and the panelists can't vote, but we should have an answer very shortly. Do you have an enduring power of attorney in place? Yes. This is given that we've heard from the Human Rights Commission in a very recent report that only 13% of Australians, I think, have an enduring power of attorney. Is that right, Brian?
That's right. And what's even more concerning is that apparently, according to the report, 88% of Australians know that they could do one. In other words, it's not as though they don't know about it. 88% know about it, but only 13% have actually done it. Now that's
Wow.
that's revealing.
Now we've
Because
got
we have this
another question
propensity.
for you.
Yeah. Yes.
I'm sorry, Brian. This is from the Compass community. While we're just waiting for the results there, do you have an enduring power of attorney in place? Yes or no? I am the carer for my brother who is permanently disabled and mentally vulnerable. He has no official diagnosis for mental regarding capacity. However, he has limited insight and difficulty with problem solving. Have you got some thoughts there, please, Brian?
Yes. It sounds like he's on the cusp of capacity or even fluctuating, which means it is now time to act for the mother to consider whether it's possible for her to facilitate her son, or was it a brother?
It's a brother,
A
yes.
brother doing an enduring power of attorney, which means that it would be probably useful for the sister to have the brother, if he's compliant and willing to do it, assessed by a medical practitioner about his capacity to make an enduring power of attorney, and if the news is good, to then have him make one.
Yeah, yeah.
Now, not next year, not tomorrow, now.
And where would be a good place for them to go, please, Brian?
In terms of a doctor, that's an entirely matter for them in terms of presumably using their usual GP, for example, for that purpose, although some GPs are reluctant to do capacity assessments. Uh, and then when you come to do the document, if you've got satisfaction about capacity, you have to do it in front of either a solicitor, a JP, or a commissioner for declaration.
Thank you so much for that. As we wait to hear about our poll, and that is, we asked you, do you have an enduring power of attorney in place? And you can see that webinar poll if you'd fill that out, and hopefully we will have a result very shortly. As we wrap up, briefly, Brian, can I have your thoughts about whether registration of enduring powers of attorney is necessary and will be a safeguard against elder abuse?
Yes, I've changed my mind on this. I used to think that registration should not be required, particularly because registration of a document at a public entity, for example, a titles office, requires you to pay money. And because it's so difficult to get people to do an enduring power of attorney, creating another disincentive by getting them to have to pay to register it wasn't in the interests of people. I've now changed my mind from experience, and the experience I have is that on many occasions, a child who abuses their parent, their first technique where they've been appointed an enduring power of attorney is not to tell anyone in the family that they have been. And secondly, when the other members of the family find out, they refuse to give to those other members of the family a copy of the document. Now, when you don't give a copy of a document to somebody who's otherwise reasonably entitled to get it, it's nice to be able to go to a registry, such as a titles office registry, where it's been required to be registered and get a copy.
Yeah.
So much abuse occurs from isolation of information. And this is a classic example of that isolation of information.
Wow.
Yes, there's no limit to a people's malevolence.
Well, Julie, what are the key messages you'd like people to take home with them today?
I guess for me, remember, I know personally for myself, it's not just for the older person. Accidents happen, illnesses happen. I have enduring power of attorney just to take the pressure off my children if that happens. So you don't have to be an older person to actually need to have one in place. I guess my motto is stay in control and plan for the unexpected. And remember that you can continue to review these things at any time. Get the right people on your team. And for anyone who is an attorney, I've discovered if you go and do anything relating to being an attorney, take that paperwork with you because you have to show it everywhere you go. And it's surprising the lack of knowledge that is out there in the community when you do go into somewhere like a bank and say I'm power of attorney, I've got my paperwork, and they still insist you need to bring the person in. So I guess it's really having a lot of good knowledge about what your responsibilities are.
Yes, and we've got in the chat that, obviously we've got resources on compass.info and all of the places you can go to get information. But there's also information in Victoria for attorneys on their duties and online info sessions through VCAT and the Office of the Public Advocate. Now, while we're just waiting for those poll results, I'm wondering, Bill, I'd really like you to tell us what's at stake here.
I suppose for me is that I've worked all my life to get where I have. And there's a legacy there I want to leave. And I don't want what happened in my family to occur here with my family. So for me, it comes back to that word or that phrase, strength of character. A strength of character for the people who I make attorneys, for them to act in my best interests, whether that be for me and my family that I love dearly. And of course, for me to have the strength of character to set up everything in place so where the best outcome will occur. But I suppose it's at stake at the end of the day. What I learnt, please attend to, if you've been diagnosed with dementia and you haven't set up an enduring power of attorney, can I say, don't fall into the same trap I did. It's something you need to attend to and do it with a lot of thought and a lot of discussion.
Thank you, Bill. We really appreciate that. And that is a call to action from the wonderful Bill Yates. And thank you, Bill. And I'm sure everyone would echo that. And of course, this has been central to this discussion today. Don't wait. Don't leave it too late. Be proactive. Be on the front foot. And of course, what we're finding from all the research is this is a crucial way of tackling elder abuse, to have this piece of paper, and it does have an impact on your future planning. As Brian says, it's more important than a will. Now, drum roll about, do you have an enduring power of attorney in place? 32% of you said yes. 68% said no. So a third of you do, 2/3 of you don't. So please, Bill, can I have you, after hearing that result, what would you say to the people in the room today?
I think it's fantastic, but let's aim for double that percentage. Let's try and make sure that we really actually are making good decisions for our people, for our parents, for our people as they get older. So 32%, it's great. It's fantastic. Let's go high.
Thanks so much. There are immensely constructive resources on compass.info. Of course, there is the Elder Helpline, 1800 353 374. We've got more webinars coming up, great resources on compass.info. And I want to thank all our panelists. You went above and beyond today. So grateful. And thank you from me, Philippa McDonald, on behalf of compass.info and Elder Abuse Action Australia. Goodbye for now.